Alex here with part 170 of the My Docket series on child custody and visitation. As my previous videos, I'll take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's criminal rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high conflict child custody ordeal from beginning to end in chronological order. We left off with the wrap up on the objection to the relocation, and we now go into a motion to have my ex held in contempt again. I can't even remember what the contents of this motion were, but I can't imagine the mindset being any worse than it is on the relocation issue, just because it's trying to erase all that hard work from virtually a year. So this here just doesn't register on my radar as an emotional moment in my case. Maybe it's because it got lumped into all of the nonsense with that hearing, and maybe it's for other reasons. I think at this point in time, we're not going to really find out until we actually go into what I or my attorney has filed. Here we have my motion for order to show cause. Standard introductory paragraph that is indicating that yet this attorney is representing me, that she's filing a motion for order to show cause. Parties in history. So this is a standard introductory, I guess you could say procedural background. I'm the natural father. Our child is 8. My ex is the natural mother. We have 2 judgments in favor of me and against my ex. So these are the money judgments. So maybe this is a contempt motion for non-payment. Let's see. My ex has failed to pay child support, failed to pay on the arrearages. We're kind of forced to deal with it this way because a judge won't let us execute on our assets. Factual background: the court entered 2 judgments in favor of me and against my ex for 13 months of unpaid child support. And we have the court's order for her to pay $50 per month towards satisfaction of multiple judgments. The court referred all the child support to the Washoe County District Attorney's Office for wage garnishment. I filed a motion for supplementary proceedings. I issued a writ of execution. Let's see. I rejected my ex's payment solely on the fact that she'd already owed this money. My ex filed her opposition. I filed my reply to her opposition. Returned the check to my ex. All of this is pretty fresh in our minds. Here we have the court entering its order denying the motion. And then we have here the court entering its order expunging the writ of execution. In its infinite wisdom, the court thought this would be a wonderful idea. And here we have my ex in contempt of court. I'm just like shaking my head at the idiocy of all of this. If the judge would have just allowed those proceedings to continue, if the judge would have just allowed us to execute, we wouldn't have to come back to court again to have my ex held in contempt. It's like I'm so sick and tired of these judges acting like they have too much work when they themselves are to blame for all of the extra work they create for themselves. This is just another example of a judge adding more work to a so-called heavy docket. If you are so busy, why would you? They're not logical. They're not rational. That's what these are the judges that preside over our cases. I don't know what she was thinking. This is very predictable. This is just my ex going into contempt again. She isn't paying any of these monies, and the court won't let us execute. So now we have to tie up the appellate courts with her nonsense. We have to fix the judge's screw ups with 2 orders reversing. We have to get my ex to pay these monies somehow because this judge won't allow us to do it the way that the legislature set forth through the law. And I mean, again, these are things that without the channel, people wouldn't believe me. People would not believe. They just wouldn't believe it. You just have to see it with your own eyes to believe the insanity that we have to go through as parents to get this stuff taken care of. Because the people who went to law school did not figure out how to handle very simple things like how to read the plain language of a statute and how execution and asset seizure works. Instead, we have to do, and it's like, and this attorney who's my friend who's helping me for free has to do more free work. I don't know. I mean, it's just more infuriating nonsense after more infuriating nonsense. So now we have all these costs for these flights that are racking up. $424 charges for the first flight, $212 for the next flight. Are we to the hotels yet? The hotels are like $500 a pop. Those are coming. We're even applying these as offset to the amounts owed. So the monies that my ex is paying for these hotels, this is how she's getting around the child support arrearages because she doesn't want to pay him. So I can tell you what she's doing. What she's doing is she's telling all these friends and family members that she's a victim of this horrible experience and that she needs them to help her pay to go and see her child. And so she's getting all these people to pay hundreds of dollars, and she's not telling them that half that money is getting reimbursed to her. This is what I think is happening. She's getting multiple thousands of dollars from these pity parties. These people are paying her this money, friends and family. She's getting half the money back in reimbursements, and she's just not telling them. So these monies are getting applied to her child support arrearages. I mean, I can tell what's going on. Nobody else can tell. The court can't tell. The lawyers can't tell. I can tell. But I mean, that's why we have this channel, right? Legal argument. I mean, these are going to be the same contempt arguments that we've issued in the past. The same old nonsense is coming back. NRS 22.010 defines contempt. NRS 22.0. You guys know this is a song and dance. You know what this is. Same cases, same statutes. Everything is the same. Just trying to hold her in contempt again for noncompliance with the court's orders. Gigantic paragraphs explaining all of this money nonsense that I'm just waiting for the notice of appeal on that other order. We'll talk about that when it comes. Lots and lots of stuff coming up in the case, guys. Lots and lots of stuff. Just remember, when you hear judges complaining that they need more help and that they have too much work and all, just remember how they create more work for themselves with these decisions that they make. They it's like a self-fulfilling prophecy with these judges. Moving on. Certificate of service under Rule 5, indicating this document was mailed to my ex's attorney. A chunk of exhibits to go through, 10 different exhibits. None of this is required. All of this work, none of this is required if you would just use the execution process set forth by the legislature. I'm so sick of them whining about what they can solve on their own. All right, so here we have swear under penalty of perjury that the following assertions are true. What is this here? Oh, this is my affidavit in support of contempt of court. So I've talked about this before. It's the Awad v. Wright affidavit. If you want to know more about this, please watch my video on the topic contempt of court. This is not something to be trifled with, guys. You have to know what this is and why it's so important. The Awad v. Wright affidavit is a jurisdictional affidavit. So if you don't comply with this, you literally deprive the court of its power to even listen to you. Like, that's a big deal. The lack of this affidavit gives the court the power to even listen to you. Without this, they don't even have any power. This is very different from the court needing to comply with this statute or that statute. Questions that go to their actual authority to even sit and preside over a case are serious questions. They're jurisdictional questions. You can also learn more about that in the videos, subject matter jurisdiction and personal jurisdiction. But I'm not going to go through this affidavit because it's going to just reiterate everything that's in the in the motion that we just went through. This is the motion opposition notice, and according to this, we do not have to pay the $25 filing fee. Exhibit 1, we have a letter from my attorney to her attorney. This is with regards to the motion that was filed. No, wait. No, this is... Okay, no, this is the letter from her attorney to my attorney. We've already gone through this, guys. This is a letter where he says he wants to send $50 to get us to go away. His check. Exhibit 2, this is the letter from my attorney to her attorney, and this is asking him a list of questions for my ex to respond to under oath to obviate any need for a supplementary proceeding. Exhibit 3, my letter to her attorney, my attorney to her attorney on more out-of-pocket expenses that are being racked up. So aside from all the money she owes, we're racking up more bills that she's not paying. Okay, we already went through this too. This is the same, okay. Letter to my attorney. After the receipt of the order denying we should work together in regards to payment of the judgment as ordered. So this is the check. So this is another letter where he is using the fact that the order was denied by the court, and he wants to get back on track with regards to payments, I guess. Something like that. I mean, it's relevant because she's in violation of the court's order again. This is another email that we've gone through. We've gone through these emails. Exhibit 6. Okay, this is the, I guess, the ledger on child support and wage garnishment amounts owed. Exhibit 7. This is my ex trying to execute some visitation. And then here I am accommodating the visit. In the future, I'm asking for at least a week's notice. So guys, take notice of this because this will come up. So she's telling me on the 28th, which is what? It's a Tuesday, that she wants to exercise a visit during the weekend, and I'm asking for more time. But I'm fine. She's going to get to, she's going to get the visit, but I'm asking for in the future more time. And this is the first of many emails where I'm going to keep telling her the same thing and she's going to keep not listening. And that ends up leading to another court hearing, which is what she wants. Actually, I don't think it leads to a hearing. I think it just leads to filings. Let's move on. Exhibit 8. What is this here? Flight reservation, boarding pass. I guess this is unaccompanied minor stuff. Oh, wait, yeah, that's right. This is the flight. Okay, and it's just more exchanges, picking up from the school. Just visits, nothing really. We have Exhibit 9. What's going on here? I don't know what this is about. What is going on here? Did she give me... Did we get no notice on this or something? May 10th, 7:54, May 9th. So I don't know, guys. I don't remember this coming up, but what I can only imagine is that she changed the flight or something. And she sent me something at 5:34 in the morning, and I respond at 7:31 in the morning that I just saw her email. What? I'm not a fool to what's going on. Midnight itinerary for a 7 a.m. check-in. This is not going to be something where I sit with him at the airport for hours. So apparently, she sent me the itinerary at midnight for a 7 a.m. flight the morning after in an email. That's what she decided to do. Unbelievable. And I'm not going to say she has no sense. She's doing it on purpose. Because if she sent me the itinerary with enough notice, then everything would have been fine, which is not what she wants. She has to engineer an outcome where conflict occurs. And so she's thinking the best way for this to happen is for me to send him a midnight email, not a text, not a phone call, a midnight email for a flight that he needs to be there at 7 a.m. Okay, this is so crazy. Oh wow, she's asking for me to just leave him at the airport for multiple hours? This whole exchange is so stupid. You guys can read through this yourself. I mean, just it's one conflict after the next. She waits until it's absolutely impossible, and then she says, "Okay, go." And then she does it again. So I mean, the same thing that she did in the morning with the midnight itinerary for the 7 a.m. pickup, she does for the 10:20, and she's probably doing it. Yeah, okay, good. So we have a 1:30, which is good. I guess that's it. Okay, Exhibit 10. Order after hearing regarding motion. What is this? Is this the old one? Yeah, from 2013. Okay, this is the old contempt order. That's it. Going into the aftermath, I filed one motion, but it was a free filing, so I incurred $0 in costs. My ex's attorney didn't file anything, so she incurred $0 in costs. I had an attorney, but she's helping me for free, so I incurred $0 in attorney fees. My ex's attorney, I was going to say 30 minutes, but the more I thought about it, the more it made sense that it was probably an hour. And the reason why is none of this motion is fluff. It's especially for this attorney because he's new to the case. Every single fact asserted, every single point of law, and every single exhibit as well is something that he would have had to take into consideration. It also would have included not just his review, but my ex and his communication back and forth to put together an opposition. So I'm not going to, of course, put all the time into that document into this because we'll deal with that when we get to his opposition. But for now, I think an hour is reasonable for a review of this motion, which at the rate of $250 an hour is going to come to $250 in attorney fees for my ex. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.